copyright holders. 1. The right to reproduce copy. 2. The right to create derivative works from the original. 3. The right to commercialize the work. 4. The right to perform the work publicly, if relevant. 5. And the right to display the work publicly, if relevant. In 1995, the right to perform a sound recording by means of digital audio was added. The doctrine of fair use was finally codified in the 1976 revision of the Copyright Act. Common law, which was well settled on fair use, was finally made black-letter law. Section 106 denotes that the doctrine explicitly applies to any use of copyrighted work for news reporting, criticism, research, scholarship, or teaching. Despite this definitive list, the fair use defense is not exclusively limited to just these activities. The Act provides a four-prong factor test to determine whether fair use has occurred. 1. The purpose and character of the use, for instance, whether it is commercial or educational. 2. The nature of the copyrighted work, how creative is the work. 3. The amount and substantiality of the portion of the original work used. And 4. The effect of the use upon the original work in the market, or potential market. Like copyright protection generally in 1976, the fair use defense was later extended to unpublished works as well. The previous term of protection for copyrighted works was greatly expanded by the 1976 revision. Before, copyright protection existed for a term of 28 years, with an optional extension of an additional 28 years. Thus, your total protection for copyrighted works was capped at 56 years. The 1976 changes provided protection for the life of the author of the work, plus 50 years. A flat 75-year term was enacted for anonymous or pseudonymous works, and works made for hire. In 1998, the Sonny Bono Copyright Term Extension Act added even more protections. Protection now extends to 70 years after the originator's death, and 95 years for works made for hire. Copyright transfers were greatly clarified by the 1976 revision of the Copyright Act. Case law had made a mess of the presumption that the otherwise uninstructed transfer of a copy included the transfer of the right to the creative work itself. That is now definitively not the case. Section 204 of the 1976 revision fully details the procedure for transferring ownership of the copyrighted work. A copyright holder must sign a written statement of conveyance expressly transferring his or her ownership of the copyright to the recipient. Otherwise, there has been no transfer of the original work. Register your work with the Copyright Office in order to enjoy copyright protection. However, one cannot pursue an act for an infringement until registered with the Copyright Office. To register one's work, the Act requires one copy and the requisite fees be deposited with the office. 2 copies are required if the work is published. The 1976 revision of the Copyright Act greatly simplified the law and expanded protections for original works. It is always good to find an attorney familiar with copyright law and the Act's revisions if you are interested in protecting your original work. Section 204 of the Act governs the transfer of ownership of copyrights. The section requires a copyright holder to sign a written instrument of conveyance that expressly transfers ownership of the copyright to the intended recipient for a transfer to be effective. Prior case law on this issue was conflicting, with some cases espousing a rule similar to Section 204 and others reaching a quite different conclusion. In the 1942 New York case Pushman v. New York Graphic Society, for example, the court held that although a copyright in a work is distinct from a property right in a copy of the work, where the only existing copy of the work is transferred, the copyright is transferred along with the copy, unless expressly withheld by the author. Section 202 of the 1976 Act retains the property right-copyright distinction, but Section 204 eliminates the inconsistent common law by assuming that the copyright is withheld by the author unless it is expressly transferred. Chapter 2. Human Resources Training. In the area of human resource management, training and development is the field which is concerned with organizational activity aimed at improving the performance of individuals and groups in organizational settings. It has been known by several names, including human resource development and learning and development. Human resources training and development covers three main activities: training, education, and development. Training. This activity is both focused upon and evaluated against the job that an individual currently holds. Education. This activity focuses upon the jobs that an individual may potentially hold in the future and is evaluated against those jobs. Development. This activity focuses upon the activities that the organization employing the individual or that the individual is part of may partake in the future and is almost impossible to evaluate. The stakeholders in training and development are categorized into several classes. The sponsors of training and development are senior managers. The clients of training and development are business planners.